For today's Supreme Court decision, we turn our attention to Ohio Adjutant General versus Federal Labor Relation Authority in the question of who is a federal employee. Federal law deals with federal employees and specifically deals with federal labor relations. Federal law requires that agencies deal with unions that exist at the federal level. So one of the questions is, well, who might a federal employee be to which this bargaining relationship is protected? In today's case, we turn our attention to an Ohio National Guard member. Are they a federal employee or not by being a member of the National Guard? Because, well, of course, they are members of the National Guard, but is that the same thing as a federal employee because of a part-time status? And they also have status outside the National Guard because, of course, they're not always a member of the National Guard because the National Guard is only a sometimes thing. So when they're not a member of the National Guard, how do we deal with that? So is this member of the Ohio National Guard? Is he a federal employee? Sometimes, none of the time, all the time. How do we determine that for labor relations purposes? Let's get started with this. As my eye decides to have a attack. Although it's my right eye today rather than my left eye, so I got that going for me. Usually it's my left eye that decides to have a completed. The Federal Services Labor Management Relations Statute provides for collective bargaining, unions, between agencies and the unions, each preventing them from committing an unfair labor practice. Both the unions and the employer cannot do unfair labor practices, and that, of course, is defined by the federal law. The law also establishes the Federal Labor Relation Authority to mitigate such disputes. At issue here, the AFL-CIO is the representative of certain federal employees, but those employees in this particular case are dual status technicians who work for the National Guard. So because they are the National Guard, they're kind of in two different statuses at once. So we're federal employees, so we're not a federal employees. Okay. After a prior union agreement expired, the petitioners here, the Ohio National Guard, asserted that the Guard was not bound by the relevant law when interacting with its Guard members. So they had an agreement before it expired. They'd like to have a new agreement, or at least the union would, and they say, wait a second, we're not bound by this law at all. You are not protected by this law. We don't have to negotiate with you. We're not going to play nice. Okay. The union, of course, filed a complaint saying, yes, we are bound by the law. You're bound by the law. You have to negotiate with us. So, play nice. Pointing to the fact that the FLRA only has jurisdiction over labor unions and federal agencies, petitioners argue the Guard is not an agency and the dual staff technicians are not employees for the purposes of the law. So fine, the Guard is not an agency, they're not employees, they're not governed by this relevant law. Okay. The administrative law judge issued a recommendation finding that FLRA did have jurisdiction over the Guard, dual status technicians have collective bargaining rights under the relevant law, and the Guard's actions of repudiation therefore violated the federal law. So yes, they're covered, says the lower court. You have to negotiate them with a union. They're covered by this law. You have to play nice. A divided panel of the FLRA adopted the administrative law judge's conclusions and order. Petitioners sought review in the Sixth Circuit, which denied relief. Okay, so we have to figure out, are they covered by the federal law or not? Let's find out. The FLRA has jurisdiction over this labor dispute because a state National Guard acts as a federal agency for the purposes of the relevant law when it hires and supervises dual staff technicians serving in their civilian role. So fine, the law protects them. They are within the meaning of this to the extent that they are employees within that role. They are governed by that role. To the extent they're not, I suppose not. But when they're working in that function, for whatever time they are working in that function, they are governed by that status. So you have to negotiate with them as they work in that status. So if they have another job, fine. But as it relates to this job, you have to negotiate with them. Okay. The question of whether the petitioners are an agency for the purposes of law when they act as supervisors of the technicians is bound by a series of defined terms. So as always, let's look to the statute. The relevant law defines agency to include Department of Defense. All right. Department of Defense is an agency within the meaning of the law. We got that going for us. The dual staff technicians are employees of the Department of Army or Department of Air Force. Okay. So they're part of the National Guard. They are employees of the Army or Air Force. Fine. The departments, of course, are part of the Department of Defense. Got that going for us. Covered agencies plainly fall within the reach of the statute. Thus, When they employ the dual staff technicians, they are components of the agency exercising by Department of Defense. So that makes logical sense. They are only part-time employees of the Department of Defense because they're in the National Guard. So only when they're called up to duty, as it were, are they doing that thing. Otherwise, not so much. But, while they're doing that thing, they're doing that thing. So fine. The statutory authority that permits the Ohio Adjutant General to employ the technicians as civilian employees in the federal service reinforces the point. Congress has required the secretaries of the Army and Air Force to designate Adjutant General to employ technicians. So, go hire these people, please, so that we have them. Great. The designation is the sole basis for their authorities to employ. So the Adjutant General of Ohio only has authority because the Secretary of the Army and Air Force say, hey, please go hire them. And so he's acting on their behalf, which makes sense. And so we hired them at their behalf. Here, the relevant order from the Secretary of the Army designates and empowers the Adjutant General to employ and administer the Army's National Guard technicians authorized for by state, as the case may be. Great. So we want to hire these people. They are under the state authority until they're nationalized. So we hire a state guy, but the state guy works for the national government. So, fine, do that. Accordingly, the dual staff technicians are ultimately employees of the Secretary of the Army and the Air Force, and petitioners are secretary designees for the purpose. Should a state adjutant general wish to employ the dual state technicians, the adjutant general must do so pursuant to federal authority. So, again, fine. There are part-timers. They're part-time feds because National Guard is only part-time federal control. So, but to the extent they are fine. The evolution of federal agency employee law and the text of the law lend further support to the exercise of authority. The relevant law explicitly continues prior practice under the provisions of executive orders, the precursor to the federal law. So this used to be done by an executive order, and then Congress decided to codify the practice by statute, except where revoked by the president or by regulation. The relevant decisions on point. The Mississippi National Guard was therefore judged similarly. There, the Assistant Secretary of Labor, exercising authority under what was then the executive order, held the Mississippi National Guard were employees of the federal government under relevant law. So at a time when it was just the executive order, the Secretary of Labor said these are federal employees. Okay. The Assistant Secretary concluded the state's Adjutant General had been designated an agent of the Secretary of the Army and Air Force, which makes sense. They answer to them. That's where they get their authority. So they're agents. Great. In employing and administering these dual staff technicians. And this agency relationship creates an obligation to comply with the executive order, which also makes sense. The definition of employee and agency examined were materially identical to the statute. So we have previously resolved this issue under executive order. Congress wrote a statute. When they did that, they seem to have adopted the language and elements. They didn't seem to change it. They could have, but they seemed to codify what was then existing. So fine. The court ordinarily therefore presumes that the statute maintains the same coverage that existed under the prior ruling. Congress could have changed it. They didn't. They adopted the same thing. So our old law is still good, because why wouldn't it be? The court therefore sees nothing to weaken that particular presumption here. Thomas delivers the opinion of the court, in which Alito and Gorsuch join for a 7-2 decision.